Good afternoon, everybody that is watching. My name's Ian Pearl. I'm a partner at OGR Denton, and I specialise in litigation, and I'm in the dispute resolution department. I have a particular specialism and interest in contentious probate. And I'm delighted I'm joined today by my colleague and partner, Richard Denton, who heads up our private client department. Richard acts for a broad range of high net worth individuals and undertakes probate trust work. We're also delighted to welcome today Sarah Harrison, who is a barrister with an expertise in chancery law, trust, probate, and also tax. Sarah is in fact ranked in the top tier of chancery barristers. And as I will repeat, we really are delighted that Sarah joins us, because the firm works incredibly, undertakes a lot of work with her, and that's why she's decided to join today. Today's topic is contentious issues in contentious probate arising out of COVID. The idea, just for those of you watching, and listening, is we don't want this, if we can avoid it, to be a dry seminar. We want this to be more of a Q&A. So please, as we get the topics moving, please do feel free to send in questions, and where we can, we'll endeavour to answer. I mean, we've titled this topic in this way, in the issues on COVID. And I would, before we really get going, I would say and ask you, Sarah, I mean, you know, every webinar at the moment will have COVID in the title. Do you really think COVID's going to have an effect upon contentious probate?
Well, I think it ties in with what we were just chatting about a minute ago. It's going to lead to more litigation, because on a basic level, if more people die, you have more disputes. But also because things have had to be done differently at the moment in terms of will preparation. And I think we're seeing it already, that this is leading to more disputes. So yeah, I think the answer is it's inevitable.
Right, okay. I mean, now picking up where in contentious probate, where the problems could arise, both generally and in the COVID situation, I think logically, I mean, the debate's got to begin at the time of the initial taking instructions and executing, and at the execution of the will. So I think at this point, I'll go to the specialist. Richard, you built your practice on this. Richard, how would you comment on taking us forward in the first instance on those points?
Well, I think, as Sarah and I were sort of chatting before, the issue you've got now is, of course, there's much more scope for misunderstanding. The fact that you can't meet a client face-to-face, the fact that you can't sit with them and go through matters, means that inevitably there's going to be a misunderstanding that arises somewhere along the line if you can't take that instruction clearly. So I think, you know, you've got to be very, very careful in the way in which wills are prepared. And, you know, that's something that we would always generally, as private client lawyers, want to look to do in the correct fashion. But I think the scope now for that misunderstanding is just that much greater. And Sarah's going to come on and talk about the fact that obviously we've got issues of capacity, undue influence, and the question is whether or not you can gauge that in the same way if the opportunities to meet your client for the first time, often in these cases, arises online. And of course, as Sarah said earlier as well, for those of you who didn't hear, a lot of wills have been prepared in a very rushed manner. People start panicking, they suddenly think, I've not put a will in place, I've got to do something, and they rush their instruction through. And that will lead to mistakes on the instruction side. I think moving to the second point that you raise on execution, that again has a number of issues that arises out of it. I think there are going to be people that misunderstand the rules and believe perhaps that things can be done differently because of the new world that we're working in. But the Wills Act has not been amended, and there doesn't seem to be any suggestion that the Wills Act is going to be amended, and therefore it is not possible for witnesses to act on Zoom. It is still the case that two witnesses need to witness the testator sign their own will in the presence of the testator. And the question is how that's going to have happened in these circumstances. So, you know, one of the things that we've been doing, and I know STEP and the Law Society sort of issued guidance on this as well, is that, for example, if you can have a couple who are neighbours of yours come and witness you through a window, that would be perfectly acceptable. But again, I think, and this arises, I think, from the general sense that I think out there people do feel, well, how's anyone ever going to know? And I think there's definitely got to be an element of that. And if they sign their will and then, you know, a couple of days later, they manage to have a cleaner pops over and sticks their name on it, and then someone else comes over to the house and manages to put the name on it, the view probably is going to be taken by some people is, who's ever going to know? How they're going to find out? You know, we don't think it's an issue, and therefore we'll do it that way, and it's fine. But if we're going into a world where things are more contentious, yeah, if I'm advising someone, I'm sure, Sarah, you feel the same way, first thing you're going to do when a will comes with a date during this COVID period is say, okay, if we're going to challenge this, let's see who the witnesses are. Where were the witnesses? And you're going to start asking questions. And I think that has a great potential to lead to a lot of problems, because I think people will have taken shortcuts.
Sarah.
Don't know how that happened. It's
No.
not often I'm mute, but anyway, it's like most things. When somebody comes in and they want to challenge the validity of a will, you start looking around, and certainly in this period, you're going to start asking about execution when perhaps in the past you wouldn't have bothered, because it's very unlikely it wouldn't have been done correctly. But if you're looking at issues like capacity, I think it's going to be routine now to query execution, isn't it?
Correct.
Absolutely. And also the taking of instructions. You know, I think every angle of challenge is a challenge angle that you're going to take, you know, particularly with elderly people, as you said, Sarah. People are going to start to try and challenge the reports that have been prepared and look at every single angle to see whether there's an issue. And I think many people will come unstuck because they'll shortcut it thinking, who's ever going to know?
I mean, Sarah, I'd just like to ask you a question at this point. Once, you know, things move on, if when one's in the future looking at a will that's been executed during the lockdown period, do you think it's going to move almost to the period point of that one would be remiss or negligent not to investigate the circumstances surrounding execution during the lockdown period?
Well, I mean, I think it should be routine to ask, shouldn't it? Because all in effect you've got to do is to say to the other side, please produce detailed statements from the attesting witnesses. If they're not prepared to do that, then you're going to be suspicious, aren't you? And then you're going to probe further. Yeah. I mean, the starting position with due execution is that there is a presumption, and the court generally bends over backwards to find it's occurred. But I think judges are going to recognise that this is an unusual period, and which is far more likely that corners have been cut. And, you know, without naming names, there are some providers who are quite deliberately witnessing wills over Zoom on the basis of nobody will be able to tell. And therefore, I think making those inquiries should be something that you do in virtually every case.
So I think that sort of raises the question, if I can just jump in and say, you know, at this stage, should we be going as far as, and I'm not convinced we should, but I just put it out there, should we be going as far as getting witnesses at this stage to confirm in some form or another that they were present at the right time? Because at the moment, obviously, we can do something about it if there's a concern or if they're not able to state that, because we can try and have things re-executed. You know, down the line, obviously, it's too late. The question is really, how far should we be going? And we don't have guidance from the Law Society on this.
Well,
to this extent.
I mean, I think the only suggestion in the Law Society guidance is give some consideration to, you know, if a solicitor is involved or a will writer, give some consideration to actually video recording the signing ceremony. And that's something that actually you can think about in any case where a will's being made that you think is likely to be contentious. And I've had cases like this where the will execution has actually been recorded, and it can be very useful. Evidence.
And we tend to do that with elder clients.
Scenario, I think the Law Society. So I think that's worth thinking about. And, you know, in relation to making wills, keeping detailed records is always key, isn't it?
Absolutely.
Okay, so we've started at least and had quite an interesting discussion on execution. I think what's been referred to even within that is one of the big issues in contentious probate is capacity. Yeah. And Sarah, I think I'd like to throw this one over to you to give your take at the outset, and then we'll see where this develops.
Yeah, so, you know, if you're dealing with probate disputes regularly, virtually in every single one, you're going to see an allegation about lack of capacity. It is simply the most common allegation that is raised against the validity of a will. And when a will maker or a solicitor's preparing a will, they're generally going to have it in mind, aren't they, to assess the client's capacity. And that's usually in a face-to-face meeting. So I think once you realise that, you know, some providers are simply accepting written instructions, some are taking instructions by telephone, there's clearly far more potential for an allegation of incapacity to be made if that person hasn't been able to carry out an in-depth assessment of capacity. And that's got to be really difficult, perhaps unless you've had a Zoom meeting that you've recorded or something like that. And then also, as you know, the wills draftsman, if you've got doubts about capacity, then you'd have in your mind the golden but tactless rule as to whether you need to get a medical assessment of the client. So again, it's possible, isn't it, to have a virtual assessment of a client, but I suspect a lot of people haven't done that they've just proceeded straight to getting the will done, rather than looking into, you know, like I say, consulting a doctor and getting them to assess their client. I think another important point is that if a probate dispute reaches court, normally the most important witness who supports the validity of the will is whoever drafted it. But obviously, if they've not been able to carry out a detailed assessment of capacity, their evidence becomes much less important, and potentially the expert medical evidence becomes more important than it normally is. So I think those sort of issues about how you take instructions are going to affect issues about capacity, but also undue influence as well, because it's virtually impossible, isn't it, in these circumstances, for the person preparing the will to be able to tell whether undue influence is involved. Somebody could be speaking to them on the phone with somebody standing next to them telling them what to say, and you can't know that. Equally with knowledge and approval, if wills are being posted out for execution, you're not going to have that normal ceremony of the will being read out to the person and explained to them, are you? No. You can send them a written explanation, but that's not as good. You can even see extreme cases where there are going to be more forgeries, can't you? Because bogus instructions are going to be forwarded, and it's going to be difficult to tell whether that's the case. So I think potentially all the main pleas are going to increase in this situation. I think the other thing that occurred to me that might well become quite prevalent is this idea of capacity being affected by a grief reaction. Yeah. It's quite a new idea. It started in a case in 2010 called Re-Key, and the court said there that somebody temporarily lost capacity to make a will because of the effect of grief when they were already suffering from the early stages of dementia. So that was quite an unusual case, because the court was quite satisfied that later the testator did have capacity, but they accepted for a period of a few weeks he'd lost it. There have been a few cases since. There's a fairly recent one that's been in the press called Clitheroe and Bond. Now that's a bit of a different one. What was alleged there was that the grief itself had caused the testatrix to develop insane delusions about her surviving child, that she couldn't be trusted and that she shouldn't leave her any property. So I'm not going to be surprised if we see these grief arguments becoming very prevalent, because you may well have a scenario in mind where a close relative died and then a spouse has quickly gone out to make a new will. Yeah. And the grief reaction argument seems an obvious one for people to raise, doesn't it?
Right. Yeah. I think this, I don't know, Richard, if I can throw this over to you at this point in time, is why it's probably so important to be taking such a detailed note of the instructions on the history. What Sarah's saying is you've got to get this understanding as to what's gone on in the client's lifetime. What impact could this situation have had?
Absolutely, and I was going to particularly pick up on the point that Sarah made about undue influence, and the point there, of course, is that it's really important. And this is always the case, but particularly at the moment, given that we don't actually get to meet the client face to face. But it's particularly important that we try and understand, A, if they had a will in place previously, what did it say? And we should always ask for a copy of that will so we can see. And then the reason for that, obviously, is to understand the changes that are now being made. And if the changes are relatively minor, or if on advice they're restructuring it because you've given them suggestions that perhaps previously they haven't sort of understood or appreciated, that's one thing. But if actually there's wholesale changes, and particularly where you have beneficiaries being written out or children being treated in different ways, you sort of have automatically alarm bells ringing, and you've got to put yourself in a position where you can actually get to the stage that you know why it is that something's being changed. And it's not obviously that it can't stack up, and it's not that it can't be understood, but I think more than ever, it's really important that we take that detailed instruction and make sure that we ask the right questions and see what has gone on before. Obviously, where there is no will, then you're not changing something, so it's a case of trying to understand why it is that a particular decision is being made. And often there'll be a very legitimate and cogent reason that the client gives as to why one person is being treated in a particular way as opposed to someone else. But often, you know, there may not be, and that then is when the alarm bells start ringing, and you have to sort of try and take them down a path to understand what it is that they're trying to achieve and why it is they're going in that particular direction. So yeah, absolutely. I think in some respects, the current situation doesn't change best practice, but what it definitely does is it means that you've got to be really on best practice and make sure that you're doing these things better than ever, because of the risks that come out of the fact you're not meeting the client face to face.
Yeah, Sarah, is there anything
I was just,
pick up on
well,
that?
yeah, I mean, I was just going to agree with Richard, because from a barrister's point,
it's not often that happens, Sarah.
I always agree with you. The biggest problem you have as a barrister is you can look and there can be a beautiful file note, but if the person preparing the will hasn't found out about why there's a change from a previous will, that can be a massive hole in your case. And probably that is the single biggest defect I see in file notes, that process is not gone through, because one of the most important factors in favour of the validity of a will is that the testator had a good reason for the change. So if that's not recorded, then there's room for speculation about why the will was changed, and it's just very, very good evidence of capacity.
Yeah,
absolutely. Yeah.
I mean, the other thing I just suppose is, you know, which we've touched upon, is the evidential information that's going to be obtained vis-a-vis medical evidence. And in particular, I just wonder, in the situation with COVID, you know, the medics don't know too much about this. If there are going to be wills that have been deathbed wills, what level of capacity has the person had in that situation?
Well, I think actually it's very unlikely there have been any deathbed wills, because as I understand it, people who are in hospital with COVID, nobody's allowed to see them. So I think in that scenario, the problems are going to come more from the fact wills haven't been made. And that's probably going to lead more into Inheritance Act claims, isn't it?
Right. Yeah.
The fact that people have been dying and not been able to make wills.
Yeah. I mean, that's one of the other points we were going to talk about today, and that's what I'll sort of touch upon now. So Inheritance Act claims, as they're known under the Inheritance Provision for Family and Dependents Act, are effectively a claim by a certain class of individuals in their relationship to the deceased who are able or are entitled to bring a claim to invite the court to set aside the last will of the deceased on the basis that the deceased's will has failed to make reasonable financial provision. And as with all lawyers, the devil is all in the detail, and Sarah will be able to recite, but she probably won't at the moment want to, countless cases on the definition and the meaning and the understanding of reasonable financial provision. In summary, what the court will do, it's a two-stage process. The court first looks, taking into account the class of individual in their relationship to the deceased. And by that, I mean, is the person bringing the claim, are they a surviving spouse? Are they an adult child? Are they a minor? Are they a partner? All of these various classes. And the court will look first on an objective basis, was reasonable financial provision made? And if they come to the conclusion that it wasn't, the court will then go on to a second stage of assessing what reasonable financial provision should be provided. And the type of provision will vary depending upon whether the claimant is a spouse or treated like a spouse or any other category. That is a very broad brush summary of the position at the moment. There's been case law going all the way to the Supreme Court that rainforests have been chopped down and written about. I think at this point, what I would like to throw out, it seems to me, as you were saying, Sarah, either wills have not been able to be written, or maybe wills have been written in a very quick manner. People haven't been able to really focus on what was important. And not only that, whoever's taking the instructions for the will, the advisor, hasn't been able or had the time to probe whether the instructions given are going to be of a type that will be able to satisfy the court's probing. Sarah, do you want to pick up on this?
Yeah, well, I mean, under the Law Society will writing protocol, this is one of the things that the will, the person preparing the will specifically has to discuss with the client and should record as to why they're not providing for particular people. So you can see, can't you, that if wills are made on the hoof, that sort of process that you quite often go through of saying to the client, well, look, there's highly likely to be a claim here. Is this really sensible? It's just not going to happen, is it? So, if they've fallen out with a child or whatever, they're just going to exclude them. There isn't going to be that conversation about whether they really should be providing for them.
Yeah. No, I think there's all those kind of issues. And I think certainly what we find, and I'll talk to Richard as well, when at the sharp end, as it were, the difficulty with Inheritance Act claims, and I appreciate the difficulty, I don't say this condescendingly at all, is that it is difficult for clients to understand that their wishes are not paramount. And it's difficult for them to understand, though this is what they want to do, that we sit there and advise and say, in fact, regardless as to what you want to do, if the court thinks that what you have done on an objective standard is wrong, you're not going to be able to defeat that. Richard, do you want to pick up on that?
Absolutely. I think you're entirely right there. And sort of from my experience, as you say, at the sharp end, it tends to be, not exclusively, but it tends to be in a second marriage situation where, you've got a couple perhaps have children from their respective first marriages. They've been together quite a long time for varying reasons. Maybe they're a widower, or divorced, but either way, they could have been in a second marriage for a long time. And they don't have necessarily the understanding that they have a duty to provide for their spouse. And the issue that arises often is that they don't necessarily mind providing for the spouse, but often it's the fact that they don't want the spouse's children to, at the end of days, receive the money that they've provided to their spouse. So they either want to give money straight to their children and perhaps provide a life interest for the spouse, and maybe give no capital provision at all for the spouse. And when obviously we advise them that isn't necessarily going to be acceptable in the situation, if you take a situation where perhaps one of the spouses is entirely dependent financially on the first to die, they will have a right to bring a claim. And Sarah, you can talk about it much more, but the starting point really is going to be a similar starting point to where a couple get divorced. And the courts are going to look to see length of marriage, provision, what sort of standard of living is expected by the surviving spouse. And if I had £1 for every time someone said they'll never bring a claim, it's just not going to happen. I could have retired by now. And the reason is because as soon as someone dies, even if the surviving spouse had no intention, if they haven't genuinely been left adequate provision, someone is going to wind them up and someone is going to tell them what they could have had out of this. And there's always going to be someone out there who's willing to do it on a no-win, no-fee, and it's going to become contentious. And, you know, I know, Ian, you're very keen on sort of going down the mediation route. And Sarah, I know you run a lot of mediations in this area because it's a sensible and pragmatic way to try and reach an agreement. But, you know, you've got to try and get there before the parties are wound up. Otherwise, it just gets harder and harder. And I think, Ian, as you say, people just don't have an appreciation that they can't do exactly what they want and that they can't leave their assets how they want and that they have to give consideration to this. And I think as a will writer, it's really important. It's really important that you protect yourself by ensuring that you give this advice and that you follow up the advice in writing. And, you know, more often than not, we advise our clients that they should be considering whether or not they have nuptial agreements. And often it's been a long marriage already. So, you know, you could be looking at post-nuptial agreements. And it's just taking the steps to guarantee you a sensible outcome to this, but at least put you in a position where you've got a chance of having a sensible and avoiding a contentiousness. And I think that's a area.
That's a good point, Richard, because in terms where you're getting instructions which concern you and you feel are touching the mark of an Inheritance Act claim, in particular with, you know, second marriages, situations like this, or a potential marriage, advising somebody to consider a prenuptial agreement, a postnuptial agreement, it's sound advice, because as you say, there are no guarantees, but at least you're flagging up the issue. I think I'm correct in saying, Sarah, isn't there? There is no case law. You cannot contract out of the Inheritance Act provisions, can you?
Well, the only scenario where that might happen is on a divorce, the court usually makes a Section 15 order to prevent a former spouse from making an Inheritance Act claim. But even that can be got around in certain circumstances. But apart from that, no, basically, potentially anybody can make a claim. And I think when you're looking at the surviving spouse, it's worth remembering that I think there's only ever been one reported case where a surviving spouse has lost. So if the surviving spouse gets nothing, it's a pretty guaranteed position they're going to win. The more difficult cases are where they get something, but you're arguing it's not adequate.
Yeah.
But I think Rich is absolutely right. The most fertile ground for litigation, really across trust law, is the second marriage, isn't it? Because another common scenario is, you know, the spouses agree that they will provide in a certain way for their children, and then what you quite often find is when the first one dies, the second one resiles from it and cuts their stepchildren out.
Yeah.
But actually claiming as a child of the family under the Inheritance Act is quite difficult, because not only have you got to show lack of provision, you've got to show you qualify as a child of the family, and that's actually not straightforward at all, and that often isn't appreciated.
Yeah, yeah, very much. As I say, I think those are the point, the takeaways. When you see it, it's being able to look at the client and just say to them, you may have to rethink. And I think the problem in the current situation is, and it's difficult, is the advisor, it's more difficult. You're not in front of the person physically. And that in itself creates, you were saying we were speaking before, I think before this formal discussion commenced, but when we were already live, Sarah, we were discussing about you doing remote hearings at the moment.
Yes.
You're saying it's harder. And I think the same is with instructions. It's lost, isn't it, without having the face-to-face.
And, you know, frankly, I think in many cases when you explain to the client that a claim's likely, they'll say to you, I don't care, but at least in that scenario, you can make a detailed note of it and explain what their reasoning was. Correct. And that, you know, that could be relevant evidence in a later claim.
Yeah. Correct. I mean, and the other thing, Ian, that I was going to just add in was that one of the things that we often do in these scenarios is that we prepare a will that's pretty flexible. And what you can do is if you prepare it in a flexible way, that then means that if actually in the end the claim isn't brought and the spouse is satisfied with what they're receiving, fine, they don't need to be receiving any more. But actually if things start to warm up and the executors and particularly the beneficiaries take a view, you know what, we don't want this to go anywhere. Let's use the flexibility that we have under the will already to make some additional provision. That can often take the sting out of it. And, you know, one of the things that we do a lot is try and have on first death this sort of flexible provision in the will under what we term an immediate post-death interest trust, which I think is a very useful tool that we can have in a will, particularly in this scenario. It's not the solution to get around the fact that a spouse does have a right to be provided for, and simply giving them a life interest, as this provision does, is not going to necessarily be adequate. But as I say, if you provide overriding powers in there so that you can appoint capital out of the trust to the surviving spouse and perhaps use that to do a deal, then it can take you away from necessarily entering into sort of pretty contentious litigation or mediation. And at that stage, you know, you can turn to a barrister.
I think there are two practical points about that, though. Yeah, I mean, what you're saying, Richard, is best practice. You know, putting in a flexible life interest trust might be a really good idea from a tax point of view. But from a spouse's point of view, if they're not happy with that, that can be the basis of the claim on its own, that they don't get an outright interest. So actually using those sort of trusts can provoke more claims. But like you say, once the claim is intimated, the trustees and the executors have actually got to start thinking about whether they can use their dispositive powers to get rid of the claim. Now, I can assure you in 90% of cases, they don't do that. They're too slow. And that's why the claim is brought, because the spouse will apply to the trustees and they'll say, oh, no, we're not making any decisions at the moment. So they're almost making a claim inevitable when it doesn't need to be.
Yeah,
absolutely. But of course, sorry, Ian.
No. I was just going to say, I want to try and bring in a couple of questions coming in from people listening. And one I'll throw over to you, Sarah, because it's on this point, on Inheritance Act claims. If someone wants to, they've got a dispute and they want to disinherit an adult child, what would you say the best steps to do that whilst trying to avoid such a claim?
Well, the best way, first of all, is to make sure they don't have any financial dependency on you. So if you don't want to leave them something, you know, cut them off financially, because if you're providing financial support up to the point of death, then their claim is almost inevitably going to succeed, isn't it? But say they're not financially dependent on you. I think what's clear from ILLIT is that there's nothing you can do to be absolutely sure that the claim won't be brought or that it won't succeed, because the only thing that I think ILLIT really told us is that the court has the widest possible discretion on how to approach these cases. So in fact, the Supreme Court said in ILLIT it would have been absolutely fine for her to get nothing, and it would have been fine for her to get a lot more. So I think what that really illustrates is that these cases are highly fact sensitive, and there's no easy way to get rid of adult claims. And in fact, most adult children just are having a punt at it on the basis that they know they're probably going to get something out of it. Because to take it to trial on the basis they're bound to lose is a very risky course of action.
As a part of that, one of the things that we often do, and look, its merits or its worth, are questionable, but I think it's worth doing it, and that's to have some kind of explanatory side letter to the executors explaining why it is that you've made that decision and giving the justification and reasons. And that in part might be that you don't regard them as financially dependent on you, or explaining some of the background and history as to why it should be that they don't inherit. It has its limitations, obviously, because at the end of the day, if someone wants to bring a claim, they're going to bring a claim, and it's then going to stand and fall on its merits, and the court are going to decide how they decide. But I think it's definitely a useful thing to have as part of your armoury in defending it.
I think the single biggest factor in Inheritance Act claims are finances. Except for spouses, they may still win without financial need. But for every other class of applicants, it's about whether they need maintenance. And the reality is you can do all the things we're suggesting, but if that adult child is in dire financial need, then there will always be a risk they will win.
Absolutely.
But having said that, there have been recent cases where they failed. The court quite often looks at if there's most reported cases involve an estrangement between parent and child, and the court quite often looks at what the cause of that estrangement was. So if, for example, the testator's perception is it is the fault of the child, recording that is a good idea.
Yeah, exactly.
So there's evidence as to exactly what's gone on.
Yeah, it all goes to, that's going to conduct, isn't it? And
Yeah.
one of the things I want to pick up and slightly moving the debate along a little bit, Richard, you touched upon in trying to deal with these Inheritance Act claims, the flexibility you try to bring into the will in the first instance.
Yeah.
Now, obviously, that sometimes that helps, sometimes it doesn't. Where I want to go is if the claim is brought under whatever head of or grounds, cause of action it is brought, what can the lawyers do? What can the lawyers bring to the table to try and facilitate a settlement and avoid this going all the way to trial? I think what I would say before I throw this out, unfortunately, when people come to me, as they do, I'm in the dispute resolution department. I say to them, unfortunately, this is about money, and that is all it's about in terms of what our role is to achieve. Sometimes people say it's about the principle, and if there are any other litigators listening, I'm sure they will be like me and tell the prospective client to run for the hills if they want to litigate over principle. In terms of being able to facilitate a settlement, but using the armour that you have, particularly in the fields of trust and tax law. Sarah, I'll start with you, and then perhaps the two of you, because in fact, why the three of us together it's important, it's useful for you all to know. We work a lot together in tandem on these kind of issues. So, Sarah, over to you on this.
Yeah, so if you're looking at settling an Inheritance Act claim, you might well have three possibilities. The first one would be, if you've got a well-drafted will and it's got a discretionary trust in it, you may well be able to use your powers under that discretionary trust to settle the claim. And like I say, the key there is to do it early and not let the dispute escalate. But there are various tax provisions that backdate the effect of that appointment out as long as it's within 2 years of death. A second possibility might be a deed of variation, again, a 2-year time limit. The Revenue have said that you can use a deed of variation effectively to settle an Inheritance Act claim. They won't argue that it breaches the rules on them because there's extraneous consideration. But again, there's that time limit. And then I think what's often overlooked is that if an order is made under the Act, it is backdated for capital tax purposes, and there is no 2-year limit on that. So quite often, you know, you see parties panicking because they've not settled within 2 years.
Yeah.
But you don't need to panic because
Correct.
as long as you get a court order, it's backdated.
Exactly.
Now, the thing to note about that is a Tomlin order is automatically backdated for inheritance tax purposes, but not for capital gains tax purposes. So basically, you need expert advice when you're looking at those sort of issues to make sure that you don't run into any capital gains tax problems. If it's a dispute involving a child and you settle it, as long as you get infant approval from the court, then it's automatically backdated. So I think the point to make is this is all quite complicated. It does involve a consideration of tax law, and that's why it can be quite dangerous not to look into those issues when you're settling an Inheritance Act claim, because you may inadvertently trigger a tax charge.
Absolutely. I think, Sarah, it's all too often overlooked, the tax implications. And in fact, I mean, we're working on a case at the moment where the tax implications of the way things were restructured through the Tomlin order has actually meant win-win for everyone, because the way the provision was made by the deceased was that assets were passing directly to children, triggering a tax charge immediately. By restructuring it and taking advantage of the tax legislation, we are waiting for revenue approval on it, but we're fairly bullish about getting that. But we've ended up in a situation where the spouse walks away with what they want at the end of their inheritance tax claim, and that's all been settled and they've had their money. And assuming the revenue do approve the application we've put in for that, the children end up with what they would have had in any event, because they've not ended up paying tax that otherwise would have been paid. And
I mean, that case is a good example, because also, you know, there are trust structures used to settle that case. And again, there can be complexity to that. It can be very beneficial from a trust point of view, but also a tax point of view, to use detailed trust provisions, but you've got to get them right.
Correct, absolutely. And I think that then goes back to the fact that in this particular case, the will created a huge tax liability without any consideration either of the surviving spouse's own position or of the tax implication that the will provided. Had the will been prepared in the sort of manner we've been discussing with the IPDI trust, for example, and considering the position of the surviving spouse, the whole position could have been dealt with, as you say, early on, without things getting heated, without things ending up needing to go to court, and probably on a fees point of view, much cheaper for everyone, and without the stress and the aggro that the actual claim brought in the end for the parties involved. So I think if you can get it right in the first place, there's no substitution for that.
Yeah.
But I think that case is a good example because it also has the horrendous complications of foreign assets. True. And I think it just sort of illustrates how complicated Inheritance Act claims can be when you have assets in different jurisdictions, you have different classes of persons to be provided for. Actually, having that trust knowledge is essential.
Yeah.
Right. I mean, I'm just picking up on that. And maybe going right back to where we started this topic, it's also critical to get sorting one's instructions out in the first place, because I think, in that case, you had a will that only dealt with English assets when the deceased had significant assets outside of England and Wales, which caused further complications.
Well, at least we're all up to speed on Sharia law now, anyway.
Indeed.
Absolutely.
Indeed.
Absolutely.
Well, I think that's been, I don't know if either of you have any further points. I think, as I say, what we wanted to do today was to identify the issues, not necessarily give a detailed analysis of different causes of action, but show that in these difficult times, both when you're taking instructions and executing a will, the best practice to be adopted and to maintain that best practice, even in these difficult times, with dealing with understanding and probing capacity. This is also going to be highly relevant, and then note-taking the issues on your understanding, and the same with Inheritance Act claims, and having that ability, even when the instructions aren't being face-to-face, to probe the client, test the client, and be able to say to the client, if you have concerns that a claim may be brought, to express them, because the client will be grateful, and you'll be doing them a good service. And if the worst way a claim is brought, you can be confident, not a case of just covering your back, but that you tried and you did your best efforts, because as Sarah said, sometimes it doesn't matter whatever you advise. If the client is intent, that's what they're going to do. That's what they're going to do. You're not going to be able to stop it. So at this point, I'd like to wind up and thank everybody for listening and taking the time to join us. You can look at our website, ogr.denton. You can be directed to Sarah, who is at Parklane, Plowden Chambers. And we hope you all stay well and safe in these times, and we will notify you when we have a further seminar, which I understand is next Tuesday at 4:30. So until then, everybody be well, and goodbye.